Hello, everyone. Warm welcome to this seminar or webinar when we're going to cover some of the things around privacy and data privacy in Europe, presented by ShardSecure. So with me also I have Hans-Peter. You can introduce yourself.
Hello, everybody. Hans-Peter Erlingsson is my name. I'm the CEO and the founder of Legem Advisory and Consulting. I'm a lawyer and legal practitioner in privacy laws and security law, primarily focusing on the GDPR.
Good. And my name is Jesper Tohmo, and I'm the CTO and Co-Founder of ShardSecure. So the agenda today, we're going to try and cover some of this. This is a very big topic, and we're not going to be able to go through all of it, but we're going to at least get a glance of some of the things, and Hans-Peter is going to try to explain some of the details around GDPR and Schrems II. After that, I'm going to go through some details around the product that we have at ShardSecure that can mitigate some of these challenges that you might have as a customer. And then also on the end of it, we're going to go through use case number 5, how the product can solve some of those challenges you might have. We also will open up for a QA at the end, but during the presentation, if you have questions, please put them in the chat question window. Okay, let's get going.
Yeah, and we will be running this for about 45 minutes, an hour, yeah, roughly. And we have a lot of things to cover today. And thanks for joining and let us walk you through the new EU-US data privacy framework to be. So where do we? Okay, here we are. So where do we start? I mean, the data privacy framework is basically the agreement between the European Union and the United States to facilitate the free flow of data between the countries. But the question is this just a bandage for the wounds, or does it actually fix any problems? That's what we are going to discuss today. Very much based on the Schrems II ruling and also the new executive order announced by the President Biden on 7th of October. But first, we must have a look at the data transfer itself. Why is data transfer such a big in the US, in the EU? And that's very much because of the transfer itself, to start with, is not a defined concept in the GDPR, which makes it a little bit fussy in terms of scope and application. What is a transfer? But you can say that it boils down to the principles of transmission and remote access. So anyone who can actually read and process data from a country outside of the European Union or the European Economic Area, EEA, is actually accessing data that resides in the EU, and that also fulfills the transfer requirement. It's also important to keep in mind that this is a constitutional matter. In the European Charter of Human Rights, the right to privacy and right to data protection is manifested, is enshrined in those articles. And transfers cannot be made if it means that there is a risk to undermine or impinge those rights. That's why transfers are restricted from the EU. And it can only occur if we use a valid and recognized transfer mechanism. And there are a few transfer mechanisms and called transfer tools. And one is what we're going to discuss today is the Commission adequacy decision and also the standard contractual clauses. And what EU is or the European Court of Justice is saying here, that if these constitutional rights are jeopardized by foreign law and practice, then the transfer must cease. The data controller has the burden of proof that the transfer is in compliance with the GDPR. So this is really the starting point, the basics. So what is the court, or what did the Court of Justice of the European Union say in the Schrems II ruling? Very briefly, well, it says that first it invalidated the privacy shield adequacy decision, and it also cast doubt on the validity of the standard contractual clauses for US transfers. This basically meant that transfer to the US from July 2020 virtually was made impossible without supplementary safeguard measures, technical safeguard measures. And the essence of the criticism directed towards European foreign intelligence activities carried out under the PRISM and upstream programs. And these PRISM and upstream surveillance programs were earlier revealed by what's the name? The upstream and the PRISM and upstream programs were run by the US intelligence community. In focus for the court was actually the legal regimes based on FISA, the Foreign Intelligence Surveillance Act 702, and the Executive Order 12333, and the Presidential Directive PPD 28. And the court found that those legislative measures and laws inadequate of safeguarding EU persons' private life in the electronic communication services, nor they're protecting their personal data or providing effective legal redress remedies, essentially equivalent to what is guaranteed by EU Charter of Fundamental Rights, as I mentioned before. So the court basically said that you cannot transfer personal data to the US, since the US legal regime on surveillance and signal intelligence undermine the rights of European citizens. So on October 7th this year, President Biden signed an executive order on enhancing safeguards for United States signal intelligence activities, this EO, as you may have heard of. The EO implements the agreement in principle that the Commission President von der Leyen and the US administration announced on 12th of March, addressing the issues raised by the court in the Schrems II case. So this new EO executive order puts the EU persons on basically equal footing with EU persons. This is at least the intention, and imposing additional safeguards to US signal intelligence activities, with the purpose to bring US law and practice to an acceptable level from a European point of view. So basically, match the level of protection with the EU level protection. So the new EO forms the basis, together with the existing privacy shield principles that actually is enforced in the US today, the foundation of the new EU-US data privacy framework, enabling free flow of data from the EU to the US. So there are some legislative improvements in this executive order. I mean, the name of it is in enhancing safeguards, so there must be some enhancements, definitely. Just the key improvements are listed here. To start with, we have now 12 legitimate objectives for signal intelligence activities, which actually forms the lawful basis of data processing. Previously, there were no such specific legitimate objectives, but there are also 5 prohibited objectives where signal intelligence cannot be used. There's also an EU-inspired necessity and proportionality test introduced, together with data minimization and storage limitation principles, which are basic principles for data protection. Bulk collection of data is still possible under the EO, but it's highly constrained and available only as a last resort measure for the intelligence community. So first, you have to use target surveillance, and if you cannot achieve the purpose, any legitimate purpose, you can actually make a resource to bulk collection. And finally, and very important, is actually the introduced two-layered redress mechanism and the implementation of a Civil and Liberty Protection Office, which acts kind of an independent authority, and the Data Protection Review Court, the DPRC, to ensure independent oversight and review of the CLPO's examinations. But there are still doubts, as you may have heard and followed media. There are some people raise concerns and objections about this executive order. Does it really walk all the way towards essential equivalence, as the court said? It's hard to say really, but there are some strong arguments why this executive order is not fully sufficient. First of all, it's not a law passed by the Congress, and it can be unilaterally withdrawn, modified or altered by the President of the United States. I think, though, that this weakness or shortage could be mitigated by an oversight body from the EU, for instance. The European Data Protection Board could exercise this kind of oversight. But what cannot be fixed is actually the DPRC, the court, the review court, is not a court of the judiciary branch. It's not a court initiated under Article 3 of the US Constitution, but it's established under the Attorney General's authority, which actually casts doubt on its independence and from the executive power. A court needs to be independent and impartial. So I think this might be something to bear in mind when assessing the EU's compliance with the Court of Justice, European Court of Justice requirements. As the Court of Justice says that in previous case law, that a court or tribunal must be independent and impartial. Data subjects, actually, those who are subject to these intelligence activities, receive no information as to whether they have been subject to an intelligence activities or not. And this also means that the rights to exercise under the exercisable rights are also limited, as you actually are not aware of what's going on. I think this is the worst or the greatest weakness of this executive order. The claimants also receive a blanket statement. If you would actually lodge a complaint, you only receive a blanket statement from the CLPO as to whether or not the violation was identified. There is no way to actually get access to the data in possession, and there's no reasoning behind the CLPO's statement either. So I think those two measures they do not really go all the way as what we were hoping for, to be honest. And I think the court will have some objections about this when this will be brought before the court for trial. I also expect that the EDPB will have express some concerns about this. And finally, the executive order leaves the US Cloud Act untouched. This is only an executive order regulating or imposing additional safeguards on signal intelligence. This has nothing to do with the US Cloud Act, which is a problem itself. So, will there be a Schrems III? Well, I think this is the question that everyone is asking. And I would say that it's not unlikely there will be a Schrems III, but first the EU Commission must adopt this data privacy framework and create it as a transfer mechanism before it can be challenged. So the Commission needs to make a decision, and before they make a decision, they need an adoption procedure. And it's actually ongoing, this adoption procedure. And there are 3 steps of this adoption procedure. First, they need to obtain a non-binding opinion from the European Data Protection Board, the EDPB. Secondly, they need a green light from the EU member states. And also thirdly, the European Parliament has the right of scrutiny over any adequacy decision. But we do expect, or at least I do expect, that the Commission will actually make or adopt this new adequacy decision and creating the data privacy framework as a legal basis or transfer mechanism with the US, and even though there might be some concerns. Commission is a political organization and it's not ruled by law itself. But as soon as the adequacy decision is being used as a transfer mechanism, well, we can expect that its validity will be challenged, either by preliminary ruling or by actual annulment under EU procedural law. And it's not unlikely that it will be Max Schrems and his NIOB organization running in the front line here. So what should organizations do then? To start with, act as business as usual. To continue to do your transfer impact assessments until the transfer mechanism is in place. Prepare for the worst. The adopted adequacy decision will be repealed in perhaps 2 to 4 years, and again leaving organization in legal limbo. Revisit your cloud strategy, and I think in the cloud strategy should also factor in data localization, geopolitics, privacy and security regulations. And finally, secure your data. Implement a multi-tier processing environment for technical safeguards measures that effectively eliminates the risk for governmental data access. And this leads us to the ShardSecure technology, right?
Yes. Thanks, Hans-Peter. So I'm going to go through some of the details around the product that we have at ShardSecure. We do micro-sharding, and I think that most of you have heard about sharding in different applications. You split data into different locations, and you use that for both resiliency and for performance. So if you look back in the old days when you had disks, you had RAID systems where you spread data on multiple parts of different disks, and that way you could also add some parity into it. You can lose some of the disk and still get the data back. So the thing with sharding as it being used in those applications is that every piece of the data contains a lot of information. It's for anything from kilobytes up to megabytes or even more than that. So if you look at privacy, that's not really going to help you. So the technology that we have patented is microsharding. So if you look at data that comes to us, what we do in the first place, we do compress it first, and then we start sharding into small pieces. And we're talking about 4-byte shards if you have privacy data in there. So if you take any account number or any private information or social security number or similar things, that will go into shards that have only 4 digits or characters, partly from that original data. So those shards will then put into new containers, and those containers will be stored wherever you as a customer decide to store them. So that means that if anybody gets hold of the data that you see on the right side of this, where you might store it in a cloud service, that data will not be complete. It will just be small pieces, bits and pieces from the original data, and you can't really make any sense out of it. So that desynthesize the whole data set, and then you spread it in different location. So this is a competitor to encryption, as we see it. It's a way for customers to start using technology and services in the cloud that you might be restricted to because of Schrems II or GDPR or similar restrictions or regulators that might inhibit you from doing that. So that's kind of the basics of the technology, and it's fairly simple as it is. It's the implementation we've done. We created a service that you as a customer install wherever you want to use it, on-prem or in the cloud. You can then decide where you want to store that data. It could be a mix between different cloud services and also on-prem if you want. And that could also, within the cloud services, it could be different regions. And if you talk about the things that Hans-Peter is mentioning, different jurisdictions and different regions that separate the data. So no single provider of the storage will have access to the data, and same thing with jurisdictions if that's a concern. So the basics of the product works like that. And what we also do then to make sure that the data is kept as it is when we get it, we do a hash value or a digest of the data. So when we get the data, we check the digest of the original file. We also check the digest of the data that we store on the right side, the new containers that we create. So that means that when we read data back from that location, we can see if it's been manipulated with, and when we put it back together, it's the same thing. So that's kind of the checks we do to make sure that the data is kept in the same way as it was before. And when we present this to customers, we usually get a couple of different questions. Two of the most common one is around what happens if I lose one of these locations. What happens if the data in one service provider is not available for one reason or another? It could be that the service is not up, or it could be that you've been hacked by ransomware or something like that. What we do is that we put parity data in one of the locations. So in this case, when we have 6 different storage locations, one of them will be containing parity data, and the 5 other ones will be sharded data. So if we lose one of them, we can still get the data back by using the parity data to recalculate the missing piece of that. So if you look on the left side, you will have an application that puts in data into our service. Usually that's stored data in one way or another. It could be PDFs or documents or backup data or wherever it might be. We present ourselves as an S3 API. So any product that supports S3 can be connected directly into it. We also present it with a nice SCSI interface, so you can get it as a disk in a Windows or Linux environment. And the application itself, just see it as a virtual disk or a virtual storage where it puts the data, and we take care of all the sharding and merging. So when we get the data, we shard it and put it in the different locations, depending on the policy you've set up. And then when the application asks for it again, we will then fetch the data on the right side, put it back together in the right order, and then send it back to the application. The other question we usually get is around performance. Of course, there are some compute needed in the software that we have to do the sharding and merging, but we can get a lot of that back by doing parallel read and writes. So if you look at a data sample that is 100 megabyte and we're going to spread it into 5 locations, it means that we will put 20 megabyte in each of the locations, depending on how much we can compress it. If it's data that we compress, it might be smaller, but that means that we can write 5 files at the same time that are 20 megabytes rather than writing one big file that is 100 megabyte. So that's where we get some of the time back from the compute that we need to do on our service. So the same goes for reading. When we read the data, we read 20 megabyte from each of the location at the same time, put it back together again. So a bit depending on how much we can do compression on the data, we usually in compare with writing directly to an AWS S3 bucket or similar, or we might be a bit faster even if the data is good for compression. So we can also set it up in multiple instances in different locations to get high availability. But normally we set it up in one region with 2 or 3 nodes. So that's how we keep resilience as well and make sure that it's fault tolerant. It's a virtual cluster that, as I mentioned, is installed by you as a customer. And so that's about it. And we are now going to go into the specifics around the EDPD, the data protection board that has been doing some information around how you can mitigate some of the requirements around GDPR and Schrems II. And specifically, there is one use case that is called use case number 5, split or multi-party processing. And this we have created a detailed document around this, me and Hans-Peter, and it's all in the download link where you can get the data or the document, you can download it. But the basics of it, as you can see from the headline here, split or multi-part processing means that you need to split the data into 2 or more parts. And that's very similar to what we are doing, except we don't limit it to 2. It's up to you as a customer to decide how many parts you want to split it into and where you want to put that. And we recommend a minimum of 5. It doesn't make sense to do 10 or 15. It could be in some cases, but 5 or 6 is usually a good number. It should be located in different jurisdictions. That's something that you decide when you set up our service. Where do you want to put the data? What regions and what locations and what services? And as I mentioned, it can also be adding one on-prem location as well to put it into. So it could be a mix between on-prem services and cloud services. The next one is that it shouldn't be revealed prior to computation. We always transfer sharded data in between. So there's no way before it's been computed that you can see the data itself. It's always in a sharded format. So that means that anybody who gets hold of that sharded data can't make any sense out of it either. Also, in the sharded data that we produce, it's an option to also put in some poison data into it. That means that we add some things that doesn't belong in there, because it's kind of like a big puzzle. If you think about puzzle pieces, that you take some puzzle pieces, put in one place and some in another place, whoever gets hold of those puzzle pieces can't really make any sense out of it because they don't have all the bits and pieces needed. And we also put in, as I mentioned, and some pieces doesn't belong to the puzzle as well. There's no mathematical computation, so there's no way that you can recreate it from mathematical parts. It's just different ways that we distribute the data and the sharded data into it. Pieces should not be able to identify. There is, in our case, no notion of where the rest of the data is. So if somebody gets hold of the data in one location, it doesn't say what object it belongs to. It doesn't say where the rest of the data for that specific object resides. So there's no way you can go to one place and then find the rest of the pieces somewhere else. And then the last one, that no storage provider should have access to all the data. And that's what we mentioned before as well. You configure it in different providers and different jurisdictions. That helps from preventing that. You can put it in different regions in Europe or different service providers as well. And as well, it maybe it's some pieces that you own yourself. So if you think about using maybe 3 or 4 different microshard containers, you can use one that you manage yourself. And that way it's even harder if that's managed by you as a customer. So let's see, do we have any? That was the things we're going to cover for now. Do we have any questions?
Maybe I could say a few things then, just to round up, because I think it's very important to keep in mind that even though there will be a new data privacy framework in place between the EU and the US, don't count on the survival of this for a very long time. Prepare for a situation where you are in the legal limbo as we are today, and always protect your data in the best way you can. So bearing that in mind, I think the split processing scenario and the use case presented by the EDPB works equally well before as after this new this framework in place, but also to protect yourself from an authorized disclosure under the Cloud Act, so to say. So the Cloud Act is there as a piece of legislation actually passed by the Congress, enabling U.S. authorities, law enforcement authorities, to by subpoena or court order retrieve data stored outside the U.S., stored in your EU cloud services, and anyone who actually use these cloud services are liable for such disclosures. So just be careful. It's not all about transfer of data. It's also data that already resides in the US, but is accessible from other countries.
Yeah. So even if you store the data in a region that is in Europe, you still might be under the
exactly. And the cloud vendor might still be subject to the to the laws of that country, of the home country, like the US, for instance, as a strong US connection by ownership, for instance, and also Chinese cloud providers are under different legislations, but with similar effects.
Yeah, that's true, and that's one of the things we talk to customers at the moment about is: are you allowed to store data even if you select one of the American cloud providers in a region in Europe? Is it still okay to do it? In most cases, it might not be, especially if you're in government or in that position when you have those things restricting you from doing that. But then you might be going to European cloud services, which probably have a higher price and maybe not the service that some of the big ones have. So you still want to use those, and microsharding is definitely one way that we could allow customers to do this. I know this will not solve all of the things that you might need, but for storage and data at rest, definitely this is one solution for it. Then you might have other solution for other things you need to protect. It's as we said, it's a big topic, and also within the topic that we are solving data at rest, there are other things you as a customer has to be aware of. So we got a couple of questions here. The first one is, you mentioned there is no mathematics behind the sharding model. You can say more about that and why it's important. So the mathematical part of it, if you look at encryption as it is, you might have heard that it could be with quantum computing be broken because it is mathematically calculated. In our case, it's not. That's why it's important we're quantum safe in that case. But also, it's not just that we do it in a non-mathematical way. It's also that we spread it on different locations. It means it's a spatial issue. Also, you need to get hold of the data in all these different locations, which is the first step you need to do. If you look at encryption, if you get the data, even if it's encrypted, you have all the data you need, and then it's more of a time and compute problem to get that data in its original format. So that's why it's a bit important that we're not mathematically in. So let's see, we had some other questions here. One is for you, Hans. Why is the Court of Justice putting higher standards on US than its EU member states in intelligence activities?
That's a very good question, and an important question. And I would say, I mean, the simple answer is that we in the Court of Justice actually put higher standards on the US because it has no authority. It has no competence to rule on member states' national security objectives. So that is a kind of a carve out from the European law, national security, and therefore it's how to say. I mean, the Court of Justice is stepping out from that area. So that's the simple answer. So basically, there are signal intelligence activities that's actually carried out within the European member states that potentially also would infringe the European Union law.
Yeah. So another one I think for you is, have there been any EU case law since Schrems II ruling that may impact or outcome a potential Schrems III case?
Well, I mean there's a change of the legal landscape continuously, and it's really hard to say. I mean, there are some recent case law that might have an effect on the Court of Justice potential ruling in a Schrems III case. I am referring to Procuratur and the SpaceNet cases, where the court said that it could actually be. It doesn't have to be a court of tribunal that oversight the processing of intelligence data. In this case, commercial electronic communication services. It's enough if it's an authority which is independent and impartial. So that I would think this could, be played as a card in this potential in the considerations whether the executive order is sufficient or not. There's also in the SpaceNet case where actually bulk collection or bulk access was found admissible, but it's hard to say. I think one important thing is what I also would like to address, which was not addressed by the Court of Justice in the Schrems II case, is actually something that's called the state secret privilege in the US, which is kind of a case common law doctrine, meaning that the national interest security may preempt the right of disclosure and the right to transparency. So if this is applied in CLPO reviews, for instance, banning or barring the CLPO, this civil liberty review office, in investigating a suspected or suspected breach of the executive order safeguards, then the state secret privilege may bar them from disclose that or actually put that to trial. I think this could be something for the Court of Justice to address in the next Schrems case. But there's a new circumstance that was not raised in the Schrems II, but it's definitely there, and that's why I think it would be good if the executive order is transformed into law passed by Congress instead. And
can you repeat the three the names of the EU cases you mentioned?
Yes, it's actually the Procuratur, that's the 746/18, and SpaceNet C793/19.
Good. Okay, we had 2 more questions there. Is microsharding a supplementary technology to encryption, or do you need both? At the moment, since this is a fairly new technology, we usually recommend customers to keep encryption for now, but we think in the long term it's going to be a replacement for encryption as it is today. The next one is if microsharding can be used for REST only, or if you can use it at data at motion. We are for REST, data at rest, that's where we focus on at the moment. We don't have anything for in motion, but the data that will be transferred from storage to where you put it back together, as I mentioned, is going to be sharded in the way that it can't be read. So good. Check if there's no more questions. I think we're getting up to the time here. As we mentioned, it's a topic where you get your addiction together with the technology. It's going to be a co-working thing for a long time, ongoing with these privacy things. We just see it, especially around GDPR and Schrems II here in Europe. But also we know that in other parts of the world, they have the same issues and same challenges. It's just maybe different ruling and regulations that are affecting you as a customer. So if you have any more questions or want us to talk more about the products or Hans-Peter on the other parts, please let us know. And I want to say thank you to Hans-Peter for attending this, and thank you to the audience for listening in, and let's keep in touch. Thank you.
Thank you.